Happy Friday. Good to see you, Maria Badillo at FPF. Maria takes care of a lot of our Latin America, Spanish-speaking, Central America, South America, important jurisdictions, Brazil, Argentina, Mexico, Colombia. I'm leaving out others, but important places. And we're going to look today a little bit at how one of the key areas down south is shaping its AI-related guidance as driven by the ANPD, the Brazilian Data Protection Regulator. I had the pleasure yesterday of being on a panel with Waldemar Goncalves, the president of the ANPD, and we discussed, this was at the IAPP Navigate, how data protection is working as a basis for the other kinds of digital governance where there's sort of overlap or synergy. We didn't talk about the conflicts, but we did talk about how regulators and law and privacy leaders are using their data protection systems to provide a base to do other kinds of digital governance. I'm also joined by Gabriela Zanfir-Fortuna, who leads our global work. And we are going to talk in particular about some very interesting guidance from the CNIL around the legal basis and how you might rely in many cases, it seems, on legitimate interest for generative AI. But before we do, what's the big news in AI this week? The big news is we in the US have two now important decisions on the $1 trillion question, which is this whole thing a big giant illegal theft of content from all of us who've been producing content, publishers, newspapers, posting online. Obviously, this question of fair use. If I, as a human, was reading all this material and looking at it in museums and consuming it in my brain, and then you said, Jules, write a song in the style of Shakespeare crossed with Taylor Swift, and because I've consumed all that content, I somehow do it in a funny way. I have the right to do that. This is brain analysis, and it is fair use to build on the work of others, even the proprietary work of others, in that manner. But this hasn't been so clear. This has been disputed because clearly this nature of mass consumption and recreation in the style of, is a giant expansion of certainly the economics and the kinds of tools that can exploit content in this way. We haven't seen the last word. There's still other important litigation, the New York Times lawsuit against OpenAI, obviously a big one, but we had a case against Anthropic and a decision in a case against Meta. And on this specific question, the court found that this is fair use. Not a surprise to people really working in copyright. Mark Lemley, maybe one of the leading scholars at Stanford, the most prolific and published, now has long written and argued that this particular question is falls in this direction. Mark is also, of course, the counsel in some of these cases as one of the leading experts. I think was the counsel in this Anthropic case, but is a long-time career authority and not just a gun for hire, but a real authority in this area. Now, the question isn't fully decided because you still can't steal the content. What you can do with the learning and how you can create material, which might end up being infringing if somebody who says, I'm going to create Mickey Mouses and then, make money selling T-shirts. But the fact that the tool can create things in the style as a system is not captured. You could still go out and, just like you could use Photoshop or with your own pen, create infringing content. But that doesn't mean you get to steal the material. You can't just go steal artworks from a museum or steal a pirated book, I mean, you still need the legal access. Now, lots of this is public and published on the internet, and we'll leave for a minute the issues around scraping and so forth, at least from the copyright point of view. But assuming you have the right to access the material, it appears that we are on the way to deciding the legal question of whether you have fair use. Now, in the Anthropic case, there will be now, the court did allow action to go forward on the basis that Anthropic had used pirated books. It did later buy them, but it did use pirated books, and so there could be liability there. And now, of course, maybe too late because all this has been consumed. Many websites are using terms of services, blocking, doing all kinds of other things to reserve those rights. And so there are still complicated questions as to whether or not the material that we get is always legally acquired, but different question in terms of fair use or legal acquisition. Okay, so that's big news. Big news is that obviously many thought that there was a good chance that the federal proposed AI moratorium that has been put into the big, beautiful Trump bill that has all the tax and all budget and, is a must pass to continue the agenda of the government. So it's going to have a sort of up and down, vote and avoid being filibustered because it goes through this very strict process. But the Senate has rules that are really just conventions. I mean, otherwise the Senate would shut down every day. Anyone could filibuster everything. So they have these conventions that they treat quite seriously, that they bind themselves with. You cannot filibuster everything and anything. And so you cannot filibuster one of these bills. It needs a simple majority, which the Republicans have, but it must be only fiscal programs. It's a budget bill, and you only can avoid these policy matters if you restrict policy matters. And this has been structured as a financial, you don't get the money that is in some budgeted programs if you unless you refrain from enforcing state AI law. So there was some thought that this would fail because obviously there's a big policy component, but the parliamentarian seems to have ruled, and now we have some indication that it's not final. There is still some discussion and debate, but it has, as far as we stand today, survived the bird bath. For those who are not steeped in the federal legislative process, Robert Byrd was a very, very powerful, very senior senator for many years from West Virginia. If you travel throughout West Virginia, everything is named after Byrd because he funded it all. He funded buildings and complexes, and there's the Byrd this and the Byrd that. But he was a real strict player on the traditions of the Senate, and so this is known as the Byrd rule. And the Byrd bath is just a bit of a joke of how the parliamentarian who is appointed by the Senate leaders and traditionally stays on and is respected as a sort of independent, accurate voice, although has been fired in the past when there were times where the new leaders did not like the decisions of the parliament. So there is the parliamentarians. So there is some history, but and some already calling for the firing of the parliamentarian because they don't like some of these decisions. But the majority leader, who has the really control over this, Thune, seems to be supportive of the parliamentarian. So we don't know yet for sure, but many critics were predicting it would not persist. And it looks like the Senate may have amended it to make it a little more nuanced, and perhaps it'll persist. Okay, so let's turn to our topic at hand, and let's start with Brazil. So, Maria, what can you share? We did a bit of a report that you led. Fill us in a bit on how Brazil is using its data protection law to shape a.
Sure. Well, first of all, thank you, Jules, for having me. Happy Friday to everyone watching us. Excited to share a little bit more about the ANPD's study on generative AI. We just to mention, we also did a blog post that goes into further detail on this study that we will be sharing the link in the chat. But yeah, very, very exciting times, definitely. So I would start this conversation by just very generally saying why this study matters in the context of emerging technologies. And an important note here is that this is not specifically or officially formal guidance from the ANPD. It is more a sort of report, or as I said, a preliminary study that was actually published by one of the technical units within the ANPD, the Brazilian DPA, as part of their technological radar series, which have the specific objective of following or tracking emerging technologies and studying them within the Brazilian context and their legal framework. So while it is not official guidance, it does provide some insight on how the ANPD can interpret or would interpret the LGPD in the future when it comes to generative AI systems. And secondly, I think it's very relevant to touch on this study because in substance, it seems to align a lot with the global trend that we're seeing, where regulators and more specifically DPAs are actively analyzing how data protection tools or specifically how data protection rights can be affected by AI. And it kind of gives us this early view into Brazil's perspective on this complex issues. So one like interesting thing about this study is how it is framed. And the study starts by saying that the LGPD has this dual nature of protecting fundamental rights, particularly privacy, data protection, and at the same time protecting innovation and achieving economic and technological progress. And so according to the ANPD, this balance is particularly challenging when it comes to generative AI because of some of its core characteristics or elements that bring special or unique challenges to data protection. And so the ANPD highlights three core characteristics of generative AI that some of the folks in the audience might be already familiar with it, but I think it's also necessary to set the stage, right? So first, the ANPD reminds us that generative AI relies on massive volumes of data for training purposes. This can, of course, include personal and non-personal data. But when we're talking about personal data, this can include sensitive, confidential information, or even children's data. The second core characteristic identified by the technical unit from the ANPD is the possibility that generative AI has to make inferences and to also create new data, and the possibility of these outputs generated by artificial intelligence to contain personal data. And the third one is the possibility of creating more complex or more advanced architectures of AI. So for instance, when we are using general purpose models and integrate them into another model or integrate them into a product, and this could raise all different kinds of questions about lawful or processing or continuous processing that it's hard to track. So considering that personal data plays such an intrinsic role for generative AI through all of its stages and during its life cycle, the ANPD identifies several challenges based on different stages of data processing, particularly for data collection and data sharing. So when it comes to data collection, first, the ANPD highlights that generative AI is often trained on data that has been scraped from different websites. And here, I would say a key reminder from the ANPD is that publicly available data is still covered and thus still protected by the LGPD. So this means in theory, that any processing of personal data that is obtained through web scraping must still be performed under a lawful basis under the LGPD. And so processors, developers must still follow the principles enshrined in this framework, such as purpose, limitation, adequacy, necessity, and to act in good faith.
Maria, let me ask a quick question. Gabriela may have a perspective on this as well, because the data that is public, let's slice this apart a little bit. If sensitive data is manifestly made public by the user, that in the Keneal assessment, and I think in general, right, and be curious whether Brazil, which has very much a GDPR type, right, framing for its law, is data that is manifestly made public by the user, even sensitive data, therefore usable under a legitimate interest basis?
Under a legitimate interest basis?
Is the legal basis, the lawful basis that we are able to use affected by whether the individual has expressly made the personal information public? Because that was one of the big areas of flexibility in allowing, if I recall, tell me if I'm right, Gabriela, that in pointing to how you might use sensitive data, which otherwise we're stuck, Article 9, restricted data can't be used. But the keynote pointed out that if you expressly make it public, then that's a different story. Then you might be able to use legitimate interest. I wonder whether Brazil addressed that, if you know, or if not, we can take a closer look and see if, did they open the door to not shutting down sensitive data in AI, which is really one of the big global problems. A lot of the countries that have a GDPR type model and have, a more express consent, or the US with some of the states, where we don't, frankly, even get that exception.
So Maria, if you, I can take this a bit, because it has been top of mind for all of the data protection authorities and data protection officers, for that matter, that we've been talking to recently. What about indeed processing of sensitive data, and particularly in the context of scraping for training, or even just acquiring data sets for training, even if not through scraping? And you're right, Jules, that if the data is manifestly made public, that is indeed one of the permissions to process sensitive data. However, under the GDPR thresholds, what manifestly made public has meant so far, at least, it is very difficult to prove that particular data has been manifestly made public. But yes, it is one of the possibilities. I would say that what is starting to shape up as a sort of thread of thought comes from, at least in the European Union, under the GDPR, comes from case law from the Court of Justice of the EU on search. And we have a number of Google search cases from 6 years ago or so, under the Right to be Forgotten series of cases, where the Court of Justice actually made a distinction when it came to search online, in between searching on purpose for sensitive data, which would account of processing as processing of sensitive data, and incidentally crawling and stumbling into sensitive data, which the court considered to be in a different fact pattern and not amount to processing of sensitive data, so therefore not requiring one of those exceptions under Article 9. Now, that case law is not, let's say, extremely expanded on. However, it exists, and I have seen it picked up recently by the CNIL in their recent guidance, which is trying to bring that thread of thought into the training for AI systems debate. And particularly this sort of more restricted regime to process sensitive data. And I'll ask our colleagues to share a very old blog from our FPF website from 2019 with really key findings from those search cases. And I think our audience will find it interesting. Now, we do know that in Brazil as well, the processing of sensitive data is a key topic, and it was really key also in the first case that we've seen. I would dare say not even only out of Brazil, but overall of sort of data protection law applied to generative AI training. And that was a case from last year in a Meta case where the processing of children data and of sensitive data was perhaps the key concern that Brazil's DPA raised. However, because their decision was preliminary initially, they engaged in this sort of back and forth with Meta to reach a solution, and that solution was reached. We also have a summary of that case. We're prepared. So I'll ask our colleagues to share these links for the conversation.
So interesting, the Costea case and the right to be forgotten cases, which many look at as these landmark, individual rights cases, you have the right to be forgotten. And of course, my complaint always is, no, these are not right to be forgotten cases. These are right to be de-indexed from Google search or other search engine cases. You always have had a right to obviously object to the publishing of your personal information, subject to journalistic or other compelling or that personal information to be there. And so, okay, how does it apply to a search engine? So we learned that, yes, you have the right to go to the search engine and demand the deletion rights. But indeed, the bigger and more compelling takeaway from those cases may not be the individual right. Because what did it really tell us? I can go to a publisher and argue, please delete me. I have the right. You're intruding on my privacy. Oh, no, you're a public figure. Okay, how does this exactly apply to Google, and whether the search engine also should give you that right when it doesn't really know what the basis is? Are you a big person, a little person, a criminal? Okay, so it was a strange, situation, but that's not really the novel case, although that was as such a big consequence. The bigger consequence is that this may have helped confirm the basis for scraping sensitive data for AI because of the actually flexible position, which the court probably took, okay, because of good legal analysis, and because the alternative would have meant breaking search, literally somehow telling Google to eliminate every sensitive category of possible, results. It would have been, and guess what? Today we're also seeing, I think, regulators being a little more flexible and open and practical. And I think the CNIL will jump in a minute to the CNIL guidance, which I think you could easily see the CNIL going in a very different direction under some of the rigid analysis they sometimes have in high-risk areas. But here did see, I think, some of the, shall we say, the benefits of AI. But anyway, Maria, any key, clearly they spotted a lot of the issues, but did they give us any paths forward using pets, or what guidance that tells us that AI is going to stay alive in Brazil, that the law is going to recognize the flexibility needed, even though there are tensions around necessity, proportionality, secondary use, all the concerns that you started mentioning? Did they give us any path forward?
Yeah, so I would say that despite this study being very preliminary and sort of descriptive of how generative AI works in general, they kind of like it feels like the conclusion of the ANPD is that, of course, some further analysis and examination is necessary to continue to analyze these very complex issues. But I would say that they give special focus or attention to two principles, which are transparency and necessity, and how developers should really take a reasonable efforts. And here, reasonable would be like a thing on its own on how much steps you need to take or what measures are reasonable to take to achieve transparency and necessity. And so, for instance, the ANPD says that when you're dealing, for instance, with first-party data, and if you are relying on consent, transparency would mean to have an adequate or a proper privacy notice where you are informing users about the potential processing of their data for training purposes, and in a clear and accessible format. And also provide them with a window or an opportunity to opt out of that processing. And that reasoning, we've seen it also in the Meta cases that Gabriela was mentioning, which was a set of preliminary decisions where basically this was one of the conditions that the ANPD put to Meta in order to continue their processing operations in Brazil.
But outside consent, did they leave the door open for other legal basis like legitimate interest?
Yeah, they definitely leave the door open for legitimate interest. And here, the thing is that you need to do this sort of balancing interest test where they do recognize that you can have a commercial or economic interest, but you need to balance it out with the reasonable expectations from users. So how much can you say that a user can reasonably expect their information to be used for training purposes? For instance, just to mention in the context of the Meta case, how reasonably could you argue that the users that were using Meta's platforms would reasonably expect their data to be used for training purposes? And so in that type of situations, you need to provide notice, and you need to provide very clear documentation and information about your processing operations, and also give them a very easy way to opt out of that processing. So that's actually a learning from these preliminary decisions from the ANPD, but it is the same reasoning it's existing in this preliminary study.
Thanks, Maria. And Gabriela, Maria said the economic interest was recognized as a important basis for legitimate interest. I think we know certainly that's the case in Europe. But what struck me from the Canil decision was that they actually gave a little more air to the high value of the benefit. I would argue, although benefit is always part of the fairness analysis in the US, under certainly Chairwoman Khan, there wasn't much, there was an assumption in many cases, like location data being shared. There was an assumption that this was likely to be harmful and certainly going to be harmful. And there really wasn't much discussion. Yes, it's assumed there's some business need, but how important it might be to the user or to society, not so much part of some of the recent FTC analysis. And I think in certainly a lot of the ed tech or other cases, how useful or valuable, no, economic, fine. But the Canil did spend some time say, well, there can be benefit to society, to all the users, and people maybe are reasonably expecting in this age of AI that data may be used for AI. I took it as a far more pragmatic decision. Many years ago, Omer Tanay and Joe Jerome and I wrote a paper because we said we need some rigor around benefit, because otherwise someone can just say, Oh, the benefit is huge. Of course, it's wonderful. I make a lot of money. Every company thinks that their role is important in society. Talk to the people in AdTech. They don't think they're bad actors. They will tell you that they're supporting competition, good consumer choice, helping new brands get in the market. I mean, this is quite true in a world of competition and economics, but not always so important to the, to all of the regulators. And here so what we did is we said, okay, well, why don't you be a little rigorous about benefit analysis then? Who is benefiting? You? Okay, that's important. Other users, that can be important. Society, that can be important. Like identify, and is it very far-fetched, very remote? Maybe that's different than immediate value. Like let's have an analysis, and then you can set that against the risk. So a little more insight from you, please, from what we saw from the CNIL this past week.
Yeah, and I highly recommend to our community and friends to have a closer read of this guidance on using legitimate interest for training AI systems. It goes into a lot of detail. It provides relevant examples from the current day-to-day sort of use of AI, which is very refreshing to see. You are right in the sense that absolutely the CNIL specifically and expressly recognizes that the broader benefits to society play a role in the bigger legitimate interest assessment, which is one of the more fascinating, let's say, legal assessments in our field. But they bring it up as part of the balancing test, which is the kind of the third step before one can decide that they can rely on legitimate interest or not for a specific, in this case, training for an AI system. The guidance particularly recognizes purposes that are very sort of aligned with the current reality of AI. So, for instance, they talk about developing new systems and features for users of a service as a legitimate interest that can be relied on. Offering a chatbot service to assisting users, another legitimate interest by itself, as long as it's particularly, let's say, coined and mentioned and put out there in the privacy policy and so forth. Now they do bring the broader benefits in quite a nice, clear way when we go to the third step, the third stage, where we have to balance the legitimate interests of the controller and the rights of the users, the data subjects, are impacted. And in that context, the CNIL recognizes that the sort of more beneficial the purpose of the AI system is, the more the balance goes towards relying on that data without consent and being able to use legitimate interest as a lawful ground. And that's very interesting. But I would also point out that the CNIL, in counterbalance, also details all of the risks that have to be put on the other side of the balance. So to be very clear, they do not provide an easy ticket out, right? They actually go very much into categorizing the risks to the rights of individuals as well, and very targeted to AI. For instance, breaching copyright is actually one of the risks that needs to be put in the balance with the very big benefits for society that training a particular AI system would bring. So that's why I think the guidance is very thoughtful. It's applied to current use cases with AI, and I promise I have no sort of deal with the CNIL to endorse what the agency is doing. But I appreciated also seeing connections made to AI Act provisions, to DMA provisions, and by the way, gatekeepers might not be able to use legitimate interest if the DMA would force them to use consent in specific cases, for instance. So, very current sort of modern look at all of these issues in this guidance.
Yeah, I maybe got sort of too excited, but I'm used to reading DPA guidance that, clearly in the end is not shutting down the activity, but creates, a very high level of burden that seems to make it, such a complicated process. And in many cases does shut down. Like the ad tech decisions over the years have sort of just progressively, made clear that risks of collecting, and you could see, you could see all of these decisions going in the same way ad tech went, where tracking people across sites, creating profiles, all these sort of activities, the risks were high, the benefits were not considered, compelling. Obviously, the e-privacy intersection around consent and ad tech didn't go away, but it is a business with lots of legal pressure. And you can see all of the risks that so many of the authorities have pointed out: necessity, proportionality. It easily DPAs could have shut down this type of activity. And I think a credit that many have looked at it more flexibly, but I think the burden is still substantial for those who wish to navigate this process. And one of our frustrations, I think, is that so much of the debate is, should we delay the implementation of the AI Act and so forth, which agreed adds even more obligations. But I would argue that the path to navigating the data protection thicket is the immediate consequence and challenge if you were really taking seriously all of the cautions and restrictions, and if individual DPAs were leaning a little harder on what users reasonably expect, on what is necessary, on sensitive data, on the legality of accessing the data. I mean, there are so many challenges. The ability to delete and remove, as opposed to just suppress. Now, the EDPB gave us some guidance as well, which was also a little bit more open than in the past, but I felt it was a little bit more. It felt a little more restrictive, right? It flagged all of the issues, but I think I didn't see it give as strong a path forward. It gave room so that the Irish DPA, who they were responding to, could then go ahead and make a decision that was going to be open-minded, and as opposed to closing it down. Here, the CNIL, I felt, gave us a bit more of a shot in the arm that this is likely to persist, even though you could see the legal uncertainty.
I would say that indeed that could be the case. Yes, the guidance from the EDPB, I have to say though that was very targeted to the questions received from the Irish DPC. So, for instance, you won't see the sensitive data processing issue in that opinion. We will see hopefully soon more guidelines with more sort of general applicability. Hopefully that will come soon. I don't know particularly what's the timeline there.
We don't have their final decision yet, or do we?
For what?
The complaint, the EDPB opinion was in response to the Irish asking for formal input in a very expedited time frame.
Yes, no, the Irish DPC, I'm not sure it came just because of a complaint or not. The Irish DPC was dealing with many questions from the developers of Gen AI systems as well. They have also received complaints, but I think one of the big decisions they had to do was whether to give the green light to Meta to process personal data of Facebook users on the basis of legitimate interest to train their AI models. And that decision came recently, and the Irish DPC had agreed that Meta can rely on legitimate interest to process, again, Facebook user data that's open to the public by the users themselves. And they had agreed on a plan, on a compliance plan, let's say, and deadlines to allow users to opt out. That deadline had just passed a couple of weeks ago. So we are already seeing consequences of that opinion. I think the Irish DPC pushed for that short deadline because they were dealing with these questions from many directions, and they wanted to have a clear opinion of the EDPB when it came to lawful grounds for processing, particularly, and also a better understanding of whether and where there is processing of personal data within AI systems. Yeah.
Richard Lyday says that the companies have already scraped the internet and compiled these massive databases. How can we remove data from the previous models? So, of course, we're only talking about personal information. And it does appear that the authorities are accepting at this point that unlearning is actually complex and not so easy to do, and models don't get updated every day, and that you do have the right to suppress your information, so it's not going to be spat out. If somebody says, write me a dossier on Jules Polonetsky, a lot of the models already try to prevent those sorts of queries. A lot of the models tell us that in scraping, they've tried to avoid like databases or express personal information. But, obviously there's news stories about Mr. Jules Polonetsky and other, things I've written and so forth. So whether or not I'm a public figure and therefore don't get the right to say you don't get to learn things about me, or I'm a private individual. So the DPAs seem to be comfortable with the notion that suppressing Jonathan Zittrain, professor at Harvard, head of the Berkman Klein Center, who was one of the co-conveners of the IPP Navigate program, you cannot search for him in OpenAI because one of his colleagues was, trying to show some of the concerns of what OpenAI would provide and different information, and so he was obviously put on we believe, on the suppress list. So if you ask for information about Jonathan Zittrain, I can't tell you anything about Jonathan Zittrain. So Richard, if your information is there, your personal information, you do have the right, unless you're a public figure or celebrity, maybe you are, but assuming you're just a good individual, and you should have the right to force the models, at least in Europe. We don't have a right to delete in all places and so forth in the US. But you do have the right to do so in Europe and in some states. But it's not. They're not mandating deletion from the model. They do leave open that might be possible in the future. But currently, they seem to be comfortable with the notion that it's just suppressing the results. Okay.
A bit like Google search, right, to be forgotten in a way, right? Delisting, delinking.
Exactly. That does not eliminate it from the corpus at all. It just prevents the results from being displayed. Thank you both. We're out of time. We hopefully shared some interesting thoughts. Thank you, and hope you all have a good weekend. Happy Friday, everybody.
Thank you.
Friday.